Okay, welcome, ladies and gentlemen, to another session of Law and Policy Discussions. So today's subject of discussion and research is the civilian trials and military courts of Pakistan. We'll be dealing with legality of such trials under the law of Pakistan and the Constitution of Pakistan. We'll also see what is the international law, what are Pakistan's international legal obligations, and what are some of the international best practices concerning this subject, right? So firstly, we'll see what is the domestic legality of trying civilians in military courts, right? So you guys can, take over. And I think who's first? Can you take over?
Yes, sir, I can introduce the team and then Kwok can, take over and start with it. Yeah. Thank you so much, sir. So I'm just sharing the screen for the topic. Can you see my screen?
Yeah, we can see your screen.
Assalamu alaikum and good morning. Good evening, everyone. My name is Amira Rashid, and I, along with my group members, Henson, Kwok, Fahad, we will be presenting the topic of the legality of military courts in Pakistan to try the civilians. So, as we all know, that on May 9th, 2023, there was violence erupted across Pakistan because the Prime Minister of Pakistan, former Prime Minister of Pakistan, Mr. Imran Khan, was arrested by the Rangers. And because of that particular incident, many followers of Mr. Imran Khan, they assaulted police officers, they set fire to ambulances, police cars, and also they attacked military personnel and the military property. So, moving forward, I would like to hand over the mic to Kwok, and he shall be discussing the nature of the military courts, and then I will be discussing the legality of the military courts to try the civilian in terms of the legal framework that we have in Pakistan, the constitution and the statutes, and then lastly, Fahad will be discussing about the case laws. Thank you.
Yeah.
All right, so in my case, I normally try to take a look at two statute law, which is the Pakistan Army Act 1952, as well as the Official Secrets Act 1923, to decide also what is the nature of the military courts. So as suggested by the name, so military courts are so different from normal civilian courts. So they have their unique rules, they have their own function, and many of the judges there are actually military officers. They are mainly dealing with some kind of military issues, and instead of calling them judges directly, normally we will call them the court-martial. So, of course, originally this is not something related to civilians, but when we try to do our further research, that we understand if something related to national security issues, or if there is some kind of, let's say, civilian casualties, or if there is any violence or other criminal cases related to military personnel, then it will certainly become a matter related to the military courts. That's why we have a very controversial issues that were just worth to have further discussion. And most importantly, we always say, unlike the civil courts, the proceedings in the military courts are not transparent enough. Many of them will conduct the trial in a closed-door manner, and general public usually have very limited participation, and they don't have any chance to go inside to take a look at the proceedings. That's why we have the problems here. And another criticism is that some of the courts do not follow the due process. There's no guarantee for fair trials to the accused, and such and the decision granted by these courts are subject to judicial review by high courts and or even the Supreme Court of Pakistan. So in this case, we do have a lot of this is the reason why we think we have to take a look at the nature of military courts. And in this case, of course, we also talk about if something related to terrorist activities, and if something related to let's say if we have some cases related to terrorist attack. So it seems we have a general practice that it should be conducted in the military court because it is a matter of national security. But if those judges or the advocates there are not well trained, they may have very limited legal knowledge, then perhaps this may cause an issue related to fair trial, and it may jeopardize the degree of rule of law in Pakistan. So that's what I like to present here. So thank you very much. Hopefully it's not overrun.
Yeah, thank you, Hansen. I think yeah, yes, Samir.
Yes, sir. Now we would like to present the legal framework that Pakistan has related to the civilian trial and military courts. So firstly, as I was speaking, that there is a very important issue that firstly needs to be addressed. That is the attack on APS, the Army Public School in Pakistan. That happened in 2014, December. So the main reason for the starting of the military courts in Pakistan was that particular act, terrorist attack on APS school. So to address this issue, the government of Pakistan and all the other parties in Pakistan, they decided to have an amendment in the Constitution of Pakistan, which is the 21st Amendment in the Constitution of Pakistan, to widen the scope of Pakistan Pakistan Army Act 1952. So what actually 21st Amendment did, it actually broadened the scope of Section 2(1)(t) of the Pakistan Army Act 1952, and it allowed the military courts to try civilians in the cases such as if they possess firearms, explosives for nefarious purposes, or aiding terrorist activities. But this amendment was not enough. So the parliament decided to make another amendment, that was 23rd Amendment to the Constitution of Pakistan, which basically was passed in 2017, and it further expanded the jurisdiction of the military courts to try the persons who did any terrorist activity in the region Pakistan, or any activity related to violence or terrorism, or which can hurt the sentiments of religious sects. So now I will be discussing a few of more statutes which deal with the legality of trying civilians in military courts. So let's talk about the Constitution first. So the first schedule of Constitution of Pakistan 1973 lays down certain laws that are exempted from Article 8 of the Constitution, and Article 8 of the Constitution states that laws inconsistent with or in derogation of fundamental rights are void. But as in the first schedule, it is as it is mentioned in the Army Act 1952, that this particular act is exempted from this particular article of the Constitution. So it doesn't fall within the ambit of the Constitution, and thus it allows the military courts to try civilians, and it also widens the scope of the military courts a lot. Also, there is another act, which is the Pakistan Army sorry, this is a rule. This is not an act. The Pakistan Army rules, it is another important legislation. It also provides the basic legal procedure that needs to be followed when anybody is arrested or anybody is detained by the military courts, by the military officials, and are being tried by the military courts. Another section which is very important in this regard is section 549 clause 3 of the Criminal Procedure Code CRPC of Pakistan, which states that when a person is arrested by the police or any army official, sorry, any armed force, can you hear me?
Yeah, I can hear you. I can hear you. Please continue.
Thank you so much, sir. And the offences which are triable by the court martial of the military courts, they can be investigated accordingly with the Criminal Procedure Rules 1970, and they also exempt the people, and they also exempt
Yeah.
I'm so sorry for the distortion. And they also exempt people that the accused can be detained for 90 days. However, the general rule in Pakistan is that within 24 hours, if a person is detained or is accused of any crime and is detained by the police forces, that person needs to be presented before a magistrate. But this particular section allows the detention for 90 days, and it is also it also widens the scope of the military courts in Pakistan. Now I would be talking about the Constitution of Pakistan, how what does the Constitution says about the military courts and the armed forces. The Constitution of Pakistan under Article 245 says that I have mentioned that the whole article here, but it would be so long. It will take so long for me to reproduce that. So basically, the gist of that article is that it gives powers to the federal government and the Supreme Court of Pakistan to exercise some powers over the armed forces. Hence, if we talk about the powers of the federal court, federal legislature, which is the parliament, and the Supreme Court of Pakistan, they can actually exercise a few powers over the armed forces and military courts. So when we talk about the Constitution, there is a particular article in the Constitution which talks about the state of emergency and internal disturbances. This particular article states that a few of the fundamental rights can be violated and can not be violated, but they can be suspended, actually only suspended for a period of the state of emergency, or when there is an internal disturbance. And when that internal disturbance and that particular state of emergency ends, the rights are no longer suspended. So, but however, if we analyze the situation of 9th May onwards, the civilians are trying to be tried in the military courts. According to Human Rights Watch, almost 33 civilians are being tried in the military courts. We are not very sure about the actual number, but this is the amount of people Human Rights Watch mentioned that are being tried in the military court. So as nobody declared the situation an internal disturbance or a state of emergency, so the rights such as the right of movement and the fundamental rights, right of fair trial, they are applicable to those people, those civilians, because they are the citizens of Pakistan and they need all the fundamental rights just like we do. So that's all from my side. Thank you.
Okay, thank you, Amira. That was very insightful. My question to you is that don't you think that excluding some of these statutes, such as Army Act, from the application of fundamental rights, and then bringing civilians within the ambit of the Army Act, violates the basic structure of the Constitution of Pakistan?
Thank you, sir, for the question. I believe that there is the basic structure doctrine, which says that the judiciary has to perform its own function, the legislature has to perform its own functions, and the parliament has to, and the executive has to have to perform their own functions. So, according to if I would analyze the situation, then there is a need to protect the defense and national security of Pakistan against the violent acts. So if the civilians do acts such as terrorism and the acts which are so violent, then there's a necessity that the armed forces come. But there is a thin line between what is the internal disturbance, or what we can actually call a threat to national security. So I think there should be a proper procedure or a guideline which the government or the parliament or even the military courts, or generally or Supreme Court of Pakistan, can define actually what is the national security element which needs to be protected. So if I analyze the 9th May situation, it was like the people, their sentiments got hurt, that the leader they follow blindly, he got arrested. So of course their sentiments were hurt. So but calling it a threat to national security or the defense of Pakistan, it is quite debatable, I believe.
Yeah, thank you so much. All right, Fahad, I believe your presentation is about the jurisprudence of superior courts. Can you please go through them briefly, like in 3 or 4 minutes?
Yeah, so Abira has discussed. Firstly, I'm really sorry. In Lahore, due to rain, the internet is really bad. Please just let me know that Amira has discussed the constitutionality of the military courts under the constitution and the relevant acts. Now I have to discuss the relevant cases, right?
Yes.
Yeah. So firstly, we have FBLE versus the state. In this case, basically the appellants challenged the provisions of the Army Act 1952, and they argued that these provisions should just be restricted to the military personnel, and they shouldn't get expansion towards the civilians. Basically, the appellant was army officer, but he was retired. So here they challenged that any person who has been retired or has been discharged from his services from army should not be tried under the Army Act, right? But dismissing this petition or dismissing this appeal, Justice Hamudur Rahman said that if we say that Army Act is the valid piece of legislation, then it does permit the trial of civilians, rather irrespective of whether they are retired military personnel or the ordinary civilians. But they can be tried by military courts under this act. And then we have another case, Mushtaq Ahmed versus the Secretary, Ministry of Defense. In this case, the petitioners claimed that the civilians were wrongfully convicted under Section 2DD of the Pakistan Army Act. Basically, all of these cases almost contain the same petitions, right? So in this particular case, the civilians who seduced or attempted to seduce the military personnel were tried under the Pakistan Air Force Act and the Pakistan Army Act. So that's why these trials were actually challenged in this case. But the court held that even if the civilians can be tried under ordinary courts, and there is a separate provision of Section 131 of the Pakistan Penal Code, but they can be tried under military courts, and the General Court Martial has the same right as that of the other courts to try non-uniformed people, just like the uniformed people if they are found guilty of offense of which they are charged with. And then we have a landmark decision of the apex court, that is the Supreme Court Bar Association case. Basically, this is the most divided judgment of a country, of the history of a country, basically. In this case, the Supreme Court got 3 petitions challenging 21st Amendment, 18th Amendment, and the basic structure of the Constitution. So, as far as the decision regarding the 21st Amendment is concerned, so the ratio of the decision was 11-6. Like 11 judges decided in the favor of the 21st Amendment and legalized the military courts in Pakistan. Besides that, it was also said in this decision that if military court takes any decision under Pakistan Army Act, and that decision is rendered mala fide or without jurisdiction, so that will be subject to judicial review by the High Courts and the Supreme Court of Pakistan. And lastly, we have Saeed Zaman versus Federation of Pakistan. In this case, actually, the District Bar Association case was actually put into action. So there were 16 people were convicted by the General Court Field Marshal, whose appeal was which went into appeal into the Supreme Court. So the Justice Azmat Saeed Khosa in this case said that since sorry, I'm really sorry. The justice held that in the District Bar Association case, it was already held that the Pakistan Army Act was effectively or incorporated in the first schedule of the Constitution, and that is immune to the fundamental rights enshrined in the Constitution of Pakistan. So the main the main challenge against these trials was that these trials were not fair, and there was no due process which was followed in these trials. So the court in this case said that the nature of the offense for which the accused are convicted is exactly the same mischief as that of which resulted in the enactment of 21st Amendment. So the court held that the trials by the Field General Court Martial was under the due process, and it did not violate any provision of the Constitution. Yeah, so these were the cases.
Yeah, thank you so much, Fahad. All right, so next one is Sabrina.
Hello, can you hear me?
Yeah, we can hear you.
Perfect. I'm just not sure if I'm going to share my screen because I'm having a lot of Wi-Fi connections, internet connections here. We have a cyclone that went through the region where I live in Brazil right now. So I'm going to share the video, but if I see that it starts to compromise the presentation, I'll just turn it back off again.
Yeah, sure.
Do you want me to share the screen?
It's okay, I'll share the screen for you. It's okay.
Okay, perfect.
Okay, you can start.
Okay, so I'll be presenting the work that was done by me, Alexandros, and also Tazan that joined the group after. Basically, our focus is if the military courts trials for civilians are legal under international human rights law, international humanitarian law. So basically, as is on the paper, international human rights instruments specify how justice is to be administered and under what conditions, but they share the same processes and same principles. So the main laws that we put into the article, I'm not sure you can see, if you could go a little bit down on the page for me, please, the next paragraph. Exactly, that exact one, thank you. So the main articles, as you can see, that we applied would be Article 8 and 10 of the Universal Declaration of Human Rights, and also the articles regarding the American Convention on Human Rights, or Pact of San Jose, the European Convention for the Protection of Human Rights and Fundamental Freedoms, as well as the African Charter on Humans and People's Rights. Basically, all of these documents reinstate the fact that people have a right to due processes of law. So they have a right to attorney, they have the right to be innocent until proven guilty, the right to a hearing, the right to appeal to a higher court of justice. All of these converge into the right of people to defend themselves as much as possible in the existence of an independent judiciary free from interference from other public authorities, which is intrinsic to the rule of law. So we analyzed the documents as well as an approach by the Human Rights Committee that is a little farther down. If you could go, please, for me, Mr. Mosen. Exactly, that's exactly it. We analyzed such a decision by the Human Rights Committee that equalizes the provision stated in an article that I will mention, that the scope of the article clearly states that military jurisdiction ought to be strictly confined to military offenses committed by military personnel. So basically, Article 14 of the International Covenant on Civil and Political Rights states that all persons shall be equal before the courts and tribunals in determination of any criminal charge against him or his rights and obligations in a suit of law. Everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law, as well as other guarantees as the ones I just mentioned. So in tandem, international human rights law, international humanitarian law recognize that a number of principles apply to each administration of justice on an international level, including equity before the courts, the right to be tried by a competent and independent tribunal, the right to effective remedy, the principle of legality, as mentioned in the notes that we presented. So considering that military courts are usually applied to different rules, applied to a different type of jurisdiction, we believe that our conclusion as a group, as much as the conclusion from the Human Rights Committee, states that the military jurisdiction should not apply to civilians. I am trying to be as concise as possible, so as we do not have a lot of time, but so I'll be moving forward basically to the best practices, because what we presented in the article was also a part of the work that Amira's group presented regarding Pakistan and how it applies in the country as well. So more moving forward in terms of best practices, that is a little bit at the end of the article we presented. I believe it's on page 5. Yes, perfect. So Alexandros also started by pertaining the legality of military courts, but also their representation throughout history, if they are fair or not. And we put in the article that although military tribunals must remain impartial and independent, they tend not to. So these procedures are not always transparent to the extent of possible. They do not necessarily recognize the same principal rights for civilians. So it is a bit of a concerning detriment in several countries. But we use the US and also other countries in Latin America as best practices. The US, although it is known for applying military jurisdiction to civilians in severe court hearings in the past, at the moment it passed the Military Extraterritorial Jurisdiction Act. So let me just update here. Perfect. The Military Extraterritorial Act was passed in the year 2000, and although the US justice system has historically allowed both military personnel and civilians to be tried by these military courts and jurisdictions, the Military Extraterritorial Jurisdictional Act, or MEJA, significantly restricted such jurisdiction over civilians. It extends federal jurisdiction over certain offenses committed by civilians who are employed by or accompanying the armed forces overseas. So at the moment, I believe that 12 civilians have been officially processed through this bill. However, it also requires that military court proceedings provide substantial rights and protections similar to those in civilian courts. So the US has a little bit of a concerning history pertaining this subject, but at the moment, since 2000, it has amended a law that allows people to have civilians to have due processes, even in military court, which would be favorable. And next up, we have also best practices in Latin America, which I find that are very interesting because the courts actually agreed that civilian trials should not be held in any way by military courts. So first, we presented the case of Brazil, that is actually my home country. So at the moment, Brazil is debating an AD, a law, uma ação direta de inconstitucionalidade, which is a law that will overwrite parts of the constitution, arguing against the expansion of military jurisdiction in Brazil and whether members of the armed forces that commit crimes against civilians during peacetime should be tried before civilian or military courts. So the historical content here in Brazil is basically that although the constitution does not allow the actions of the military in the national territory other than wartime, they are still participative of civilian day-to-day life, especially in certain regions like the Amazon or Rio de Janeiro. So basically, the government has routinely contracted employed the armed forces as a public security measure. And for this reason, there are hundreds of civilian deaths and claims of excessive violence and civil rights violations all over the country. So this law would be very important to argue that military courts in Brazil do not meet the demands for accountability regarding crimes against the civilians, and also to diminish the impact of the military throughout the country. Sorry for the noise. And lastly, we also presented best case practices in other countries from Latin America, but focused in Mexico. So here we have 3 cases: Radila Pacheco versus Mexico in 2009, and also Rosendo Cantu and other requirements versus Mexico in 2010, and Cabrera Garcia and Montiel Flores versus Mexico in 2010 as well. In resume, basically, all of these courts agreed that military jurisdiction should be reduced and even eliminated in democratic states during peacetime, and that prosecuting civilians during military courts is a human rights violation, and that such investigations should be entrusted to an independent body and provide civilians with all the due processes of law as established in international and legal documents.
Thank you so much, Sabrina, for that very insightful presentation and the research note. I'm sure we can convert this into a law blog to be published. And the same for Amira as well, and Fahad as well. All right, so my final question to you, I think, Sabrina, is that do you think that Pakistan is violating its international obligations, since it is part of ICCPR and ICESCR, by trying civilians before military courts? You are muted, Sabrina.
Yes, I know. I'm sorry. It's just that my computer is a bit old, and so it takes a while to unmute myself. But yes, I do think that it is against human rights law. Although I was not present for the initial presentation of Amira's group regarding the laws, the national laws, the Pakistani Army Act, and other sorts that we also studied when doing our own research, I think that to determine the legality of using military courts for civilians should be exceptional, limited to cases where the state party can show that resorting to such trials is necessary and justified, and even then that the civilians have due processes of law guaranteed. So by international human rights standards, I think Pakistan has no basis to try civilians in military courts, and the violations stemming from these procedures in Pakistan demonstrate a flagrant disregard for due process, considering the lack of transparency. From what I've studied, coerced confession and executions, and practically unfair trials.
Yeah. Thank you so much, everyone, for this wonderful session. It was very insightful, and hopefully we'll be holding these sessions regularly, and in like every 8 to 10 days. Thank you very much for your time, and we'll see each other soon. Thank you.
Okay, thank you, everyone. Have a great day.